This is my task today, this afternoon, to introduce how the Hungarian Constitutional Court interprets the fundamental law, what methods it uses. I have divided my presentation into 5 parts. I would like to speak briefly about the Constitutional Court and its members, the powers, the competencies of the Constitutional Court, briefly the procedure before the court, the criteria for selection, and I'd like to turn to my main topic, the interpretation of the fundamental law. So first, the Constitutional Court is a 15-member body operating separately from the legislature, the government, and the judiciary, and it is the principal organ for the protection of the fundamental law. The members are elected by the members of parliament by 2/3 majority of the members of parliament. It is also true to the president of the Constitutional Court, who is elected from amongst the justices of the Constitutional Court. It is said in legal literature that the president has a traditionally strong position in the body, not only in the case of equalator votes, but also when he assigns the cases to the judge rapporteur. One cannot find rules under the Constitutional Court Act or in the rules of procedure how to exercise this power, and what are the criteria for assigning the cases to particular judges. So it is at the discretion of the president, and as far as I see, it is very important at the outcome, from the point of view of the outcome, who is the judge rapporteur of the special case, the particular case. Actually, the president, on the one hand, as far as I know, takes into account the workload and also the special expertise of the judges. For example, a complex criminal case is assigned to a justice who is a professor of criminal law, and it is reflected in the 30 decisions selected for the purposes of this research. Then I'd like to say some words about the competencies of the Constitutional Court. You can see those tiny green signs behind the competencies in which the Constitutional Court delivered the decisions selected for the purposes of this research. The most important and most frequently used competence is the specific norm control, including judicial initiative and also constitutional complaint. As I remember, almost 70, 80, or maybe 90% of the cases is constitutional complaint, and we distinguish between 3 types of constitutional complaint. The first one is when the law applied in a final judicial decision is challenged. The second, when the judicial decision itself is challenged. The difference is under the case law of the Constitutional Court that when the interpretation of legal provision is not in conformity with the fundamental laws, and the judicial decision shall be annulled. Why the piece of law hasn't got an interpretation which is in conformity with the law, or all the possible content of the provision is contrary to the fundamental law, then the law shall be annulled legal provision. There is a third type of constitutional complaint called direct complaint, when the affected party can initiate the procedure before the Constitutional Court when the law has a direct effect on the petitioner without a judicial decision. The Constitutional Court exercises other competences as well, for example, abstract norm control, ex ante and ex post review before and after promulgation, examination of conflicts with international treaties, and it has also competence in interpreting the...
Sorry for the interruption. We can see a list of the beginning of your PPT. That was your...
Okay. Then I try to this way, is it?
Okay, it's okay.
Is it better? Okay.
Yeah, of course.
Yeah, thank you. So examination of interpreting the fundamental law in an abstract way, the examination of parliamentary resolution related to the Odin referendum, removal of the President of the Republic from office, never seen such a motion, examining local government decrees, or the decisions on the uniformity of the law delivered by the Curia, etc. There are quite various constitutional
problems with the network.
I think so. At the beginning of her presentation, she will try to reconnect. Therefore, I would like to ask your patience.
So, sorry for these technical issues. Adél has disconnected, but Professor Szilágyi suggested us that we should start the discussion just when, until Professor Köblös will arrive, and I will have some questions, exactly two. David, are you here with us? No?
I think that he left.
Yes, he has left. Congratulations in the absence of for his child. Okay.
Pardon. Excuse me, may I have one comment? I have no question, but one comment which I want to share with you.
Yes, please.
If I may. Okay, listening carefully all the presenters of this very interesting project, I'm very sad that Macedonian Constitutional Court practice is not a part of this extraordinary research, I could say. Hope that maybe in the future, if you have some maybe update version of the data of this research, or maybe follow-up project, I'm not quite sure for the form, but maybe in the future, in the near future, we could maybe include the Macedonian Constitutional Court practice and work in this academic research project. I also hope that this publication will be published and have electronic version, I hope, because this publication could serve as a very useful and valuable tool for our Constitutional Court judges in their work and also in the process of making decisions in the field of fundamental rights protection. So the experiences which are coming from the Central and Eastern European countries are valuable for our country, and I hope that the judges could use this tool, this instrument, this publication as an instrument for their maybe upgrading their knowledge, and maybe to have sufficient material, comparative material, which they will use in their work. So I hope that all this research will be visible for Macedonian people and for the Macedonian scholars and judges too. Although the Macedonian Constitutional Court is very, I must say, modest and have limited competencies of fundamental and human rights protection. Maybe Macedonia is one of the latest country which is not introduced the constitutional complaint in the constitutional system. Although we as an academics are always pushing the government and the legislator to amend the constitution in this manner and in this way, but we have no success until this moment. The lack of the constitutional complaint is actually the problem of Macedonian citizens. We have some kind of request for protection of human rights, but that is not the similar institute, the similar instrument, a similar tool. And that's why I think that sharing with all your experiences through this publication with Macedonian judges, it will be very useful for them to educate them, and especially to direct maybe their attention to the EU law, because this is something that they are missing and they are not using. The EU law is something like I don't know, the island, which is not known for most of our judges. The European Convention is useful, and they are using in their judgment, but rarely using in their judgment. In this manner, I want to only to share with you that this type of conferences, seminars should be broadened with this kind of public, especially the Constitutional Court judges public. And I would like to mention this as a proposal maybe for the next conference, to include the Constitutional Court judges in our discussion and in our research projects. Thank you very much.
Thank you for your comments. Professor Szilágyi, do you have some remarks for this?
Yes. Thank you so much for your proposal. First of the thing that I would like to detail this part of this project in my closing remarks, but it's no problem, of course. First of all, it's worth noticing that not this presentation, but the research behind this presentation will be published in a book. Now you could listen to the different chapters of this book, of course, merely a kind of conclusion. That is the first outcome of this research group. Besides the members of the group, they will also publish their findings in scientific articles. These articles can be, our plan is they will be published in open access journals. I think it's quite important. As to the book, we would like to disseminate these books, especially in this region. And the first noticing that we are absolutely open to the North Macedonian. Therefore, if you can send us, for example, contacts of this forum, we are devoted to send our books, for example, to this forum.
I will. Thank you. I will send you a contact. Yeah.
Besides these publications, of course, the Central European Professors Network also organizes numerous dissemination events. We had approximately 30 events in this semester, and this event can be found on the internet, on the website of the Ferenc Mádl Institute. We have an English website as well. It's worth noticing that we try to upload the videos of these conferences and meetings and roundtable discussions and Oxford debates and so on the website. It's worth noticing that we are in delay. Therefore, we would like to ask your patience to upload these videos. But both the previous event videos and the future videos, in the next semester's dissemination event videos, will be uploaded on this website. Therefore, I hope that we can somehow propagate, support your research via our channel. But of course, we are open if you can somehow make a kind of advertisement for our research. Thank you so much.
Yeah, I will.
Okay, thank you. And Professor Köblös has reconnected to us, so the floor is yours again. Please make the presentation.
Thank you. Okay, I make a new attempt to share my PPT.
Maybe if you don't upload the presentation, the signal will not be so occupied. So that might be able to. If you
okay,
just
then I use and you.
And we want
you will not see at least use it. Okay.
At least we can listen to, yes.
Okay, okay, thank you. So I am sad that I was lost at the third slide. Am I right? Have you heard about the competencies of the Constitutional Court?
Yes.
Yes. Then the procedure before the Constitutional Court. Not.
About the first.
No.
No, nothing.
Was not. No, was not.
Okay, then I turn to. Okay, I return to the competencies of the Constitutional Court, and then I continue from this point. The most important competencies of the Constitutional contained as system control, decisions out of the 30 selected ones is constitutional complaint, and we distinguish between three types of constitutional complaint. It doesn't matter what three types. Actually, in some decisions, different types of constitutional complaints are examined and answered by the Constitutional Court. There are other competences as well, for example, abstract norm control before promulgation of an act of parliament, or after promulgation of the act of parliament, or at any other decree of the government or the members of government, also the local government. The examination of conflicts with international treaties, interpretation of the fundamental law, in an abstract way. These were the competence in which the Constitutional Court delivered the selected decisions. There are others as well, but I would like to skip it and turn to the procedure before the Constitutional Court.
Sorry for interrupting you, but we cannot see your slides.
I know, because I haven't shared them. Keep the connection between you.
It would be better that we could see them.
Okay, I try again.
Maybe turn off your video, because it makes the connection a little bit better.
Okay.
Can you see it now? Not yet? Okay.
Yes, we can.
Okay, oh, no, not yet, because I stopped sharing. Now. Again.
Okay, it works.
Okay. So the procedure before the Constitutional Court, the motion must be filed in writing with the Constitutional Court, which comes to the Secretary General first, who can make a proposal for a single judge to reject if the motion is obviously unsuitable to initiate the procedure before the Constitutional Court. Other motions come before the President, who assigns the case to the Rapporteur Justice. And I don't know whether you have heard that I talked about how the President assigns the cases to the Judge Rapporteur. Actually, he exercises quite wide discretion in assigning the cases. And I think it is important with the Judge Rapporteur of a certain case. In constitutional complaint cases, first the judge rapporteur prepares a decision whether to admit or dismiss the constitutional complaint, whether it raises a constitutional issue of fundamental importance or affecting the decision of the challenge before the Constitutional Court. Then the draft decision is prepared, usually by the legal advisor of the judge rapporteur, and submits to the plenary session or to a panel. There are decisions that shall be delivered by the plenary session, for example, the annulment of an act of parliament, the annulment of a uniformity of law decision of the curia, abstract interpretation of the fundamental law, or the president of the court, or the effected panel, or any other 5 justices of the Constitutional Court can refer the case or transfer the case to the plenary session because it raises a social, an important issue of social importance or constitutional importance, or if the case is complex, or it is necessary in order to maintain the unity of constitutional jurisprudence or for any other reasons. The procedure is conducted in writing, in one-sided. There is no public hearing held in the course of procedure, and there are no interveners. It is not contradictory, and it is reflected actually in the reasoning of the Constitutional Court. What were the criteria for selection in my research? First of all, that each decision of the Constitutional Court should contain a significant reference to judgment of the European Court of Human Rights. I have found even decisions dealing with not fundamental rights, but interpreting other provisions of the fundamental law, and even in those decisions I have found references to the judgments of the European Court of Human Rights. I have selected only the decisions of the plenary session because of the important role in unifying the case law of the Constitutional Court, and with 2 exceptions, decisions published in the Hungarian Gazette, which is the official journal of the Republic of Hungary, and under the Constitutional Court Act, certain decisions must be shall be published in the Hungarian Gazette, while others can be at the discretion of the Constitutional Court, and usually the important legally, constitutionally, socially important cases and decisions are published in the Hungarian Gazette. I selected one to select cases related to different fundamental rights and different types of cases. Then I'd like to turn to the main topic of my presentation, the fundamental law. 2 provisions from the fundamental law. The first one is Article R, paragraph 3, that the provisions of the fundamental law shall be interpreted in accordance with their purposes, the national abode contained therein, and the achievements of our historic constitution. As far as the purposes are concerned, I have found approximately 6 decisions relying on the objective purposes of the propositions. So this method of interpretation doesn't play as important role as one could think in the light of this provision. Can you hear me?
Yes.
No.
Yes, we can.
Oh, thank you. Then it says that the national abode should be taken into account. The national abode is the preamble of the fundamental law, and also the achievements of our historic constitution should be taken into account in constitutional reasoning. But I think that nobody knows what qualifies an achievement of our there's a vivid discussion in legal literature what this phrase means, but as far as I know, until now, the Constitutional Court hasn't made an attempt to explore the essence of this phrase in the fundamental law. And looking at the selected decisions, both national approval and the achievements of our historic constitution play only decorative or illustrative role. The other provision of the fundamental law is Article 28, saying that in the interpretation of the fundamental law, one should assume that the provision of the fundamental law serves moral and with common sense and the public good. I have found one reference to this article, and the Constitutional Court hasn't clarified what this provision means, what the essence of this provision. What about the case law of the Constitutional Court, whether the Constitutional Court established or elaborated its own system of interpretation? I have already mentioned previously that as far as I know, no, there is no such a system, not only in the selected decisions, but in generally. So I cannot say what methods are acceptable by the Constitutional Court and what weight it attaches to certain methods. There are only partial declarations concerning certain methods, and I will return to this issue a bit later. Here I have listed some methods not applied at all or just rarely used, for example, professional other than legal meaning, logical interpretation, contextual interpretation in the narrow sense, case law of ordinary courts, normative acts of other domestic organs, historical interpretation, and legal literature. I have heard about the different solutions, the different approaches from different countries. The Hungarian solution is that I have found 5 or 6 references to scholar works, and all these relate to other branches of law, for example, criminal law, civil law, but never constitutional law, fundamental rights. Then some words about the results of the research on the basis of the selected decisions. The most popular, the number one method of interpretation is the reference of the previous cases of the Constitutional Court, and here I have to draw your attention to a special phenomenon in the Hungarian case law, and it goes back to 2012 when the fundamental law came into force, and the question was raised whether the previous decisions delivered under the can be referred to, can be relied on or not. In 2012, the Constitutional Court established a test, but a bit later, the Constitutional provision saying that all previous decisions of the Constitutional Court cease to have effect, whatever it means. It might mean. It's not clear what the aim was with this provision by the Constitution maker. But in 2013, the Constitutional Court elaborated a second test, saying that the content of the relevant provisions of the previous Constitution and that of the fundamental law shall be compared and considered in great details, and the use of arguments contained in the previous decisions must be justified in sufficient details. It has become possible, open for the Constitutional Court to disregard legal principles mentioned in the previous Constitutional Court decisions even if the provisions of the Constitution and the fundamental law are the same. On the basis of the selected decisions, I have found that in some decisions the Constitutional Court can test in great details, as one can expect it. But in other decisions, this was carried out only in a formal way or at all. It wasn't carried at all. So it seems that reference to the previous case law is automatically occurs. It's automatic without using in every decision this test. What is the second most popular method is the contextual interpretation in the broader sense. I have a citation here from one of the selected decisions saying that in the exercise of its powers, the Constitutional Court shall continue to interpret and apply the fundamental law in accordance with its aim. System and will consider and measure against one another every provision of the fundamental law relevant to the decision of the given matter. So I have found that the Constitutional Court quite often, I think there was only one exception to this, takes into account other decisions of the other provision of the fundamental law, and the most popular provision amongst these is the rule of law provision, including legal certainty. What about grammatical interpretation? I would say that everyday meaning is not in the spotlight of the case law of the Constitutional Court. Legal meaning plays much more significant role, especially if we take into account that dogmatic interpretation forms part of legal meaning, and the Constitutional Court develops its own dogmatic system from decision to decision. So when there's a reference to previous Constitutional Court decision, it doesn't mean that the Constitutional Court tries to find a similar case as far as the facts are concerned, but it refers to its dogmatic system from the basis. But sometimes this part is quite long in the reasoning of the decisions. Legal principles are also important in the constitutional reasoning. I have listed some of them from the decisions for the data transparency, in dubio pro libertate, popular sovereignty, social publicity, favor testament, in nebis in idem, verbality, publicity, immediate as procedural principles, non crimen sine lege, judicial independence, but there were others as well. What about the international agreements and the case of international courts, the comparative method of interpretation? The Constitutional Court laid down a principle, and I've cited on this slide, saying that the court accepts the level of legal protection provided by international legal protection mechanisms as the minimum standard for the enforcement of fundamental rights. The roots of this principle comes back to a decision delivered even before the entry into force of fundamental law. It's interesting that it was under the fundamental law. Nevertheless, what about international agreements? I have another citation from a decision given in an abstract interpretation competence, and in the holdings of this decision, the Constitutional Court saying that in the interpretation of the fundamental law, the Constitutional Court takes into account the obligations binding Hungary on the basis of its membership in the European Union and under international treaties. It continues in the reasoning that the fundamental law should be interpreted as far as possible in a manner to make the content of the norm comply with the law of the European Union. It is also generally accepted that other international agreements, including the European Convention of Human Rights, provide the standard for the protection of human rights. Nevertheless, sometimes these provisions interpretation of law reasoning of that there's quite ambivalent even though I think that there is a great influence on the constitutional reasoning of the Constitutional Court. Nevertheless, there are some justices in the body who are quite.
Sorry, would you be so kind as to repeat your last 4 sentences, because there was a kind of interruption.
Okay, right. So there is an ambivalent attitude towards the judgments of the European Court of Human Rights, and the reason for that is possibly who are quite against to adopt the reasoning of the European Court of Human Rights and judgments of the European Court of Human Rights, and who heavily criticize the European Court of Human Rights itself. So therefore, the judge rapporteur sometimes decides in order to reach majority in the body to not to refer to judgments of the European Court of Human Rights. What about other judgments of foreign judicial organs? I think that not in the selected 30 decisions, even though I have found references to the judgments of those courts, you can see on my slide, but Constitutional Court, there were much more frequent references to the decisions, judgments of 2 foreign courts. One of them is the German Federal Constitutional Court. As far as I know, in the early ages of the functioning of the Constitutional Court, sometimes, quite usually, the Constitutional Court translated parts from the decisions of the German Constitutional Court and adopted it in this way into the Hungarian jurisprudence. The other is the U.S. Supreme Court. How much the Hungarian Constitutional Court bases its decisions on statutory law? There is one striking phenomenon in the Hungarian Constitution. It relates to the right of access to data of public interest. The Constitutional Court repeatedly says that it is customary to limit the scope of data concerned on the basis of the relevant provision of the Act on Informational Self-Determination and Freedom of Information. So actually the definition of the data of public interest comes from statutory law. As far as the tests are concerned, we've got a general test for restriction of fundamental rights in Article 1, Paragraph 3, and this is the generally known proportionality test. And under the light of the selected decisions, I must say that carrying out this test is not so clear in the judgments of the Constitutional Court. We've got a specific test relating to the right of property and the prohibition of discrimination, and there are some absolute rights. For example, fair hearing is qualified in the Hungarian Thank you for your attention, and sorry for losing